Well, Shannon, what do you think? Should we get started?
I think so. The seventh person just joined, so we should be good to go.
Perfect. Great timing. Well, thank you everybody for joining. First of all, this is so important to take the reins of your retirement plan and create your own plan. We have seen time and time again that adult children, typically the oldest daughter, is making these decisions for her parents, and that's puts a tremendous amount of stress and guilt on the family. And so, first of all, just thank you for being here. That's a phenomenal first step. And I think we just lost Shannon, I think. Oh, there it is.
Can you see it?
Yes, thank you.
You're welcome.
I was going to say, it's going to be hard for me to get through this presentation without being able to see your slides. So as I was saying, thank you for joining. This is a joint presentation between Commonwealth Senior Living and Hook Law Center. So we'll be kicking off today from Commonwealth Senior Living, kind of talking about how to get started. And then Shannon with Hook Law Center is going to be picking it up from there on really all the individual pieces that you'll need to get started. So with no further ado, so like I said, thank you for being here. Over 49 million people over 65 in the United States, and of those, 70% will need some form of senior living. And honestly, most individuals don't have a specific plan in place. Only about 1% of the population is really familiar with senior living options because either they work in the industry or have helped a family member through the process. So congratulations on being here in the first place. You've made the right first step. And if you want to move on to the next. So really the face of senior living, what options are available have changed dramatically over the last 40 to 50 years. Really up until the 1980s, seniors who couldn't live on their own or didn't have help with family didn't have a lot of options. And we've progressed so far up to this point that there's a wide variety of options, from really 55 plus apartments, independent living, assisted living, memory care, and skilled nursing, and everything you can imagine in between. And so we can understand how it would be a little bit overwhelming to start looking into what your options will be. And really one of the main reasons you want to start thinking about this now is that there's just such a high prevalence of Alzheimer's disease. So according to the Alzheimer's Association, 5.5 million Americans are living with the disease now. And, you know, a good amount of them are under 65. So they're not, you know, what you might expect. 200,000 are under 65. So typically 1 in 9 individuals 65 or older have dementia or some form of, have Alzheimer's or some form of dementia. And as you can imagine, that really impacts every aspect of life. So this is why we plan, right? So this is kind of the purpose of why we're getting together today. You know, we see that typically speaking, every 6 months after the age of 65, something happens, whether that is a fall or a complication of a chronic illness, or, you know, even pneumonia or things like that can create more difficulties. And so, you know, planning is incredibly important. And really, as I was saying before, it's a gift to your family. I will say I myself recently went through putting a family member, you know, choosing a community with very short notice because of a fall, and putting a family member into an assisted living. And we only had about a week to find the right community, and it was out of state, and I never even got to walk in person, and that isn't uncommon. And I'm sure none of you are wanting family members to make choices like that for yourselves. So creating this plan ahead of time, not only does it provide that gift to your family member that they won't worry if they've made the right choice, you also get to decide now what the right fit will be for you in case that decision needs to be made when you can no longer articulate it yourself. So first things first, as I was saying, you really want to think about what is the ideal lifestyle for you. So number one, what do you envision your senior living lifestyle to be? Even as specific as, maybe have you grown up, did you always live in an urban setting? Is it going to be important that you stay in the heart of a city? Or do you want to be able to look out your window? Like I'm thinking about one of our communities that has a full view of the cornfield next door. And almost every single one of our communities every one of our residents in that community grew up in that rural area, and that's their comfort level. So think about that, how big of a community you'd like to be in, what kind of activities you'd like to enjoy, and then look at your financial picture and what financial parameters you need to stick within. And then finally, meet with professional advisors that can help make your idea a reality. So that's going to be your elder law attorney, your financial planner, and your doctor. All right. So, again, really thinking about visualizing the ideal lifestyle. So when you close your eyes and you imagine what this community is going to feel like, what does your suite look like? How much space do you feel like you're going to need? Do you have heirloom pieces that absolutely need to stay with you because they're so meaningful? Do you want to have a dog or a cat with you? And then what kind of activities do you want to do? I mean, it's really thinking about what's the ideal day going to feel like for you, and who would you like to be surrounded by? Being at home on your own is really isolating, and just as human beings, we weren't meant to live in isolation. We're a social species. And so, do you want to be in a place that's nearby friends and family? And then also just all of the kind of frustrating things about daily life, the cooking, the cleaning, home maintenance, all of that, you're probably going to want to have that taken care of. So think about what food matters to you. And then finally, most individuals don't want to have to move again. So if you're downsizing, the likelihood of you wanting to move again to, have everything packed up and sent to another place and start life fresh in another community, you're probably not going to want that. So think about the progression of care of what's available. Okay, so then looking at your finances, this is where if you have a financial planner or a wealth advisor, this is the opportunity to bring them in, and they'll want to pull everything, your monthly gross income, so your pensions, IRAs, Social Security, as well as annual income from dividends, capital gains, and then look at your long-term care insurance. You're going to want to look at what the monthly cost is, as well as what the benefit includes. And then also looking at any assets. So owned real estate that would be available for sale or rent. And then finally, everything that will benefit you that you can take advantage of. Like if you or your spouse was a veteran during wartime, you would have access to Veterans Aid and Attendance. We also work with Elder Life Financial, who can provide bridge loans. And then of course, long-term care insurance, has a very specific benefit that they can contribute to. So pulling together everything that's available to you is the great next step. And actually an important thought on that, when we finish here, we'll provide you with our email address. And if you're interested in a cost comparison tool, it will show you what you're paying now for your cost of living and what the cost of living could be in a community. And a lot of families have found that that's helpful when making plans. So if you email us afterwards, we'll send that over to you. Okay, engaging the professional team. So this is when you've got a good idea of what you're looking for. You've met with your financial advisor. You've got an idea of how you're going to pay for senior living. We're going to be talking next about your relationship with your elder law attorney, preparing your documents to make sure that everything is protected, your trust, your will, all of your desires are legally put in place, a realtor who can help you with either the rent or sale of your property, and then also a physician to make sure that everything is considered and that there's a comprehensive care plan in place with the community of your choosing. Okay, so you've got an idea of the lifestyle you're looking for. Now you want to look in person at the communities in the area that you'd like to be in. So this is where the research is key. You can learn a lot online, both from reviews, websites, take a look at the video of what families are saying and what it looks like in there, but really nothing can compare to going into a community yourself, and really unannounced. If they're not expecting you, you're going to get an idea of what the community really feels like, without them, putting on a, specific planned tour for you. And think about, how does it feel? Do the people look like they're enjoying themselves? What's the food like? What do the suites look like? More than anything, I think you can tell in the first 10 to 15 minutes in a community if people are happy there. And then make sure, it's so important to communicate your plan. And Shannon will talk a little bit more about getting these documents in order. But once you've completed your POA, your power of attorney, your will and trust and advance directives, so important that your family members know where they are and how to access them. And also that they know where you would like to be and what it will mean when you're ready. So make sure that they're aware of what your wishes are so that they'll follow through with them. Okay, so smooth transitions. So this is really when you start getting into the nitty gritty. We recommend partnering with elder law attorney and a realtor and making sure that you're not doing this on your own. You've got professionals with years of experience that can help make it a smooth transition. We can also help coordinate with movers, give you an idea of the floor plans and help you lay out the furniture, and essentially work with you to get it all scheduled so that it doesn't feel like what it may feel like, which is taking a lifetime of memories and experiences and things and moving them into a totally different location. That can be very overwhelming. As much as you can break it down into smaller pieces and let professionals take over, I think you'll find that it will go a lot smoother, and we're all very happy to help. So at this point, does anyone have any specific questions about how to get started choosing a community or what steps they should take?
So I am watching the Q&A, and Eric, I don't know if you can see it or not, but I am watching it. I don't see anything yet. What I will say is that as I'm going through my piece of everything, if anybody does have questions, feel free to go ahead and put them through. I've unfortunately done more Zooms in the past year than what I have ever expected to do in my life. So I kind of monitor everything that's going on over here. That said, I'm going to go ahead and jump into kind of the legal piece of all of this. And so for those of you that are not in Hampton Roads, Virginia, just to kind of give you an idea, my firm very much focuses on elder law itself. And I always tell people that elder law is not technically estate planning. It incorporates estate planning, but really what it encompasses is looking at planning for death and disability in terms of what benefits are also available. So there are a lot of very great estate planners that are actually my really good friends, but they really don't understand the intricacies of, let's say, Medicaid or aid and attendance pension, or even just something simple as Social Security or Medicare. all those benefits go into whatever the long-term plan is that we develop. And so that's really what makes a real elder law attorney stand out. I am licensed in both Pennsylvania and Virginia with my primary office here in Hampton Roads, Virginia. We also have attorneys that are licensed in New York, Massachusetts, Georgia, and North Carolina. So those are the states that we can really service and help develop plans for. For those of you who may be in a state that we cannot service in, or you just want somebody closer, one of the first really good points to find a really good elder law attorney is going to be through the National Elder Law Foundation. And the reason why I point to them first is I have what's called a certified elder law attorney designation. There's only about 500 of us in the country. It's about a 30% passage rate for the exam. And then we have to be peer nominated. We have to demonstrate that we've had like so many cases in different subsect areas and that it's not just regular traditional estate planning. So that's really kind of, I think, if you're looking for an elder law attorney that you're not really familiar with, you're going to find a great resource through NELF, that National Elder Law Foundation. Secondarily, then you can also look to the National Academy of Elder Law Attorneys, another great organization that we're heavily involved in. My partner, Letha, actually is the current president of the National Academy of Elder Law Attorneys, and then even the Special Needs Alliance as well. So those are kind of the three resources that if you are looking for somebody well-versed in what it is that we do, that's kind of your point. Ron, I do see that you have your hand up, so I'm going to allow you to talk. Oh, you're muted.
How about now?
You're good now.
Okay. You've been talking about elder law attorneys and so on and so forth. And supposing a person already has their finances in order and also they have their long-term care documentation in order, and what they want to do is they want to have someone with knowledge on the communities that are available, which is not, I don't think you have a list of communities. I don't think you work by trying to place a person into a community. If I'm wrong about that, tell me that.
Yeah, so, Ron, we could help you with that.
Yeah, so it's something that obviously Commonwealth definitely knows, but your local elder law attorneys are going to know the resources that are available. I mean, if I get a client that comes in here and I'm going to use my knowledge of Commonwealth in particular, you know, in Hampton Roads area, to find a non-ambulatory license in an assisted living community, not on the memory care side, is a pretty rare feat. The only place that I know that actually has that are the Commonwealth facilities. And so whenever I have somebody that comes in that's specifically looking for assisted living, doesn't need memory care, but maybe mom and dad can't walk anymore, or maybe they can't walk, you know, that's a great thing to be able to say, you know, Commonwealth Senior Living, that's where you really need to go, because once you get into like an ADL requirement, and we're going to get into that in a little bit, you know, unfortunately, a lot of the facilities are not going to be able to accommodate, and you may end up in like a nursing home, which isn't going to provide the quality of life that you're otherwise going to want. Commonwealth is the facility that can accommodate that. They have a couple different little programs that just because I work with them and under other facilities, I understand exactly, you know, certain things like, I've had a couple emergency situations where I can easily get a call, pick up the phone and say, hey, this is what I got going on. I need emergency placement. You know, they have some different respite programs that other places don't have. And so your elder law attorneys, because this is what we do and we're working day in and day out with assisted living facilities, memory care facilities, nursing homes, continuing care retirement communities, whatever, the adult daycare centers, we do actually know. So we may not have a list and say, hey, go do this. But a lot of the placement agencies, what I'll tell you is they're going to throw your name in a mass email and basically say, hey, contact this individual. They're not necessarily going to direct you to a placement to accommodate what your needs are either. So that would just be my advice, is that your local elder law attorney should know the facilities and the really good ones.
Yeah, I guess what I was trying to do is there is a gap between me being so-called organized, you might say, with uh, the official documentation. I have a long-term care insurance plan, so on and so forth. But what I lack is knowledge of what facilities are out there that are suitable for, let's say, my particular interests and my capability to pay for them and so forth. So how do I sort of go from I'm ready to move, but I don't know where because I don't know what the market is.
What state are you in?
Pardon?
What state are you in?
Virginia.
Oh, you were in Hampton Roads?
Well, I'm right here in Virginia Beach, where you are.
Oh, okay. So what I will tell you is if you give me a call, we can definitely fill out your needs, or you can contact anybody over at Commonwealth who can also, each of the facilities, what I'm going to tell you is, let's say that you are interested in one of the facilities. The nice thing about Hampton Roads in particular, sorry to bore the people not in Hampton Roads, is that there are so many communities that there's a network in particular for Commonwealth here in Hampton Roads. And so, for instance, if you have an interest in Georgian Manor because you've always been around Chesapeake, but they don't have like a male bed available there, then they can look at one of their other sister communities and then maybe transition you whenever they do have that bed availability. So even if it's a place that you like, they may not have the opening at that point in time, but I would say your starting point should be to reach out to them, or really sitting down and saying, okay, these are what my needs are, what facilities are out there, because everybody's needs are very familiar or are very specific. But what I will tell you is, based on my experience, Commonwealth is one of the only ones that whenever I talk about assisted living, can actually carry you through going in independent or semi-independent through their Independent Living Plus program, where there's just medication management, all the way up through some pretty heavy, we use skilled nursing kind of differently, because I use the nursing home level of care as a skilled nursing care requirement, where it's basically like activities of daily living care. And they often use more like ventilators and trachs and wound care and stuff like that as a skilled care definition. And so really, aside from that vent care, those types of things, Commonwealth can actually maintain you. And what I can tell you is, from practical experience here in Hampton Roads, that's not always the case. And so, I don't want to just focus on placement issues, but what I will tell you is we do know the facilities in the area and can help guide through what is the best in your circumstances. But just from a basic level here in Hampton Roads, Commonwealth is the one, and that's why we partner with them so often, is they're the ones that can maintain our clients throughout the vast majority of their aging process.
Well, for example, I visited the facility down, when you go down Dam Neck, probably, and you cross over General Booth. I don't remember the name of it, I'm sorry. You probably know.
Was it King's Grant? Does that sound right?
Atlantic Shores, I think.
Okay.
Does that sound like it's right?
Yeah, that's a continuing care retirement community.
Yeah, I'm just throwing that out as an example. It's not connected to Commonwealth.
Right.
So it's just a competing facility, put it that way.
Right.
So, and there are other competing facilities in any area. So what I'm driving at is, if I know a lot of stuff about my ability to go to wherever I would want to go, but I don't know what are the choices. How do I learn about the choices? Is there an organization or I don't know that I need to go to an elder law attorney to find that out. I wouldn't think that elder law attorney would be canvassing all of the nursing homes or retirement places to get an understanding of all of them and how to. Pardon?
What I would tell you is that we do. We know all the facilities in the area. The ones that were just built, oh yeah, we know their pros, we know their cons. So we do that. What I will tell you is there is no agency that will do that. So there are some agencies that are placement agencies that are going to put your name on a list, basically blast it out to a bunch of facilities and say, hey, call. But they're not going to necessarily guide you through the process. There are some like nurse case managers, stuff like that. But really what I will tell you is that we do know the facilities in the area. Everything from the only things that we don't know are the unlicensed group homes, and we don't recommend those.
I'm sorry, the only thing you don't know is what? I didn't catch that part.
There are these unlicensed group homes, and we do not recommend them for liability purposes. They basically are not regulated by the state. And so anything that's not above board with the state, we don't keep in touch with.
All right. So then I need to have a relationship with your organization, or you as an individual or something. And there may be others in your company that would help me understand what are the choices.
Yes.
Depending on my situation, which everybody's got a different situation.
Correct.
So that would be the way to kind of like, I mean, I have family members that might step in and help canvass the area, but they're not here. And to buzz in for a weekend or a week or 2 weeks, it would be a laborious process, and they might miss something that would be the best placement.
It's
just because you can only
time-consuming process for sure. And what I will tell you is, if you call my office, we'll talk about it more. But I mean, I can't stay on placement. I gotta kind of get through it more. But we know the facilities in the area. Is all I can tell you. Okay.
Okay, I understand. So that's what that answered my question, and I know what I have to do.
Okay. All right. So to get into kind of what are we going to discuss about? And so whenever I look at this from a big picture level, we have to plan for death and disability. I think as a culture, we don't necessarily want to. But when you look at the statistics, about 25% of all individuals will suffer some sort of disability. 1 in 9 individuals who reach 65 will develop some sort of dementia. And then 1 in 3 who reach 85 will actually develop some sort of dementia. And guess what? 100% of us are all going to die at some point. One of the things as an elder law attorney that I look at is that the power of attorney is really your most important document. The vast majority of powers of attorney that I see walk through the doors, whether or not they be created online or in another lawyer's office that just does traditional estate planning, what they're really designed to do is just provide some basic level planning. They do not necessarily allow for the integrated plan that needs to be developed when you are looking at long-term care planning. And so that's going to look at both legal and financial components, but there also has to be what are called hot powers built into it. So most states will say that there's certain things that are so inherent in nature to you as an individual that unless you expressly provide the power to do them, you won't be able to do them. And so a large number of plans or documents that I see are going to limit gifting, for instance, to the annual gift tax exclusion amount. The downfall to that is if I need to do a big plan where I'm shifting assets, it's not going to allow me to do it. And so I do carefully walk through, in particular, that power of attorney. I think a lot of my clients focus on wills and trusts and all that other fun stuff, but really making sure the power of attorney is going to last you not only now, but in the event you do have, let's say, a traumatic brain injury and we need to do some really advanced planning for you. I always say that the documents that we develop are just tools in our toolbox to be able to develop the plan. I also tell my clients that I'm giving you your documents for free. What you're really paying for is the integration of developing the legal and financial plan, which those documents will back into. And that's just because without that plan, I don't care how good of a trust you may have. If you don't have it properly funded, some of the purposes of the trust actually are not going to be served. So that's just kind of the way that I look at things whenever I'm planning. In the event that you do not properly plan, there are defaults under the law. And in particular, if an individual doesn't have a plan or they don't have capacity, we could be subjecting ourselves to guardianships and conservatorships, or an inheritance may pass in a way that you don't necessarily want it to. So really, planning encompasses you taking the reins and doing what's in your best interest. Okay, so what are the tools? So whenever I'm looking at developing a plan, I am looking at powers of attorneys, the hot powers inside of a power of attorney, advanced medical directives, the advanced medical directive will actually consist of both a power of what's called a health agent or medical power of attorney, and then your living will built up underneath there. Representative payee process, joint ownership, trusts, and wills. So as you can see, there's actually a lot more than even legal documents that I would draft. As I indicated previously, the power of attorney, and we're not trying to think of this because most of my clients do want to focus on death planning, but your power of attorney for a long-term care plan is the most important tool in the toolbox, because that's going to allow us to really carry out your wishes while you're alive. And so the number one most important thing is going to be to select an agent that you trust implicitly, and making sure that the terms that are in your power of attorney, you actually want in there. There are some things that if they're not in there, your agents would be able to do, such as pay your bills. However, certain things like being able to initiate a divorce, being able to actually establish and fund a trust, to be able to make withdrawals from the trust, those are all powers that need to be expressly provided inside the power of attorney in order for your agent to actually be able to carry out those things. Then we look at your advanced medical directive. So depending on the state, you may actually have a healthcare proxy and your living will. In Virginia, we do combine one into an advanced medical directive. So essentially, you are appointing an agent who will make decisions for you when you can't make them. In Virginia, what I can tell you is 2 doctors actually have to opine that you don't have the requisite capacity to make your decisions. And then you have your living will, which is going to really outline what it is that you want to have happen in the event that you're in some sort of condition to where life prolonging measures might be necessary. And so you think back to the Maria Shivo case, I think it was out of Florida, where the family fought for years over whether or not life support should be had. Those things do happen. And so having that living will to spell out, yes, I do want a ventilator. No, I don't want the machine beating my heart for me. Do I want food and hydration? Do I consider that a life prolonging measure? That's really what we're spelling out in that advanced directive. Our documents are pretty lengthy. Now that said, I have seen lengthy documents that don't spell out everything that we need. Some of it just has garbage stuff in there, like business related issues when my client never had a business to begin with. But I do see like 2-page living wills that just don't really expand upon certain things. Based off of our experience, some of the things that we do put in there is like appointment of a guardian. So in the event that something were to happen to you where you need to protect yourself. Ideally, I don't want to do a guardianship if you have a power of attorney and advanced directive, and I'll get into what that is and what that all entails later. But essentially, it's the court determining that somebody's incapacitated and appointing a different individual over individual to make decisions. However, I do have clients that have been exploited, and so the power of attorney, while yeah, it's fine and dandy to be able to manage their affairs, the problem is that individual can still get to their assets and still continue to be exploited. So sometimes we have to lock that down. Your documents should expressly state, in the event that I did need a guardian and conservator, this is who I want to do it. The other big important thing that we put in there is the ability to take away keys, because especially with advanced dementia, even when somebody's license has gotten taken away, there are times where our clients have continued to try and drive and not only endanger themselves, but endanger others. Representative payee is actually a little tool that's not as familiar to people unless you've actually had to experience. So if you look at, or if you go back to, elementary school when we're taught about just basic government, anything not expressly reserved for the federal government is a responsibility of the state. And so what happens is there are certain assets that people hold that are still controlled by the federal government. So if you think about DFAS for military retirees, Department of Veterans Affairs for our veterans, civil service for our civil service employees, or even Social Security for most of our retirees. Those programs are all federal in nature, and so they do not respect a power of attorney. So instead, you have to be appointed what's called a representative payee in order to manage those types of assets. So we try to avoid this as much as possible, just because it is cumbersome. It requires a lot of accounting to the federal agencies, and it takes a really, really long time to get this put in place. So that is another tool that we sometimes have to use. I see it a lot with my kids that were disabled prior to age 22, or actually even later in life. But whenever we have to turn on something like SSI or SSDI, it's quite frequent that we do get a representative payee appointment there. Joint ownership, this is probably my least favorite tool, and it's because it actually creates a lot of problems. Basically, what I see happen a lot is that in lieu of getting a power of attorney or advance directive, somebody throws one of their kids onto their bank account. So let's say it's your daughter, Jane. She gets thrown on the bank account, and different states have different rules with regards to how that bank account's treated, both during life and at death. But for the vast majority of states, if it's a joint ownership account, it's going to be with rights of survivorship, unless you otherwise elect to do it without survivorship. In Virginia, the form is supposed to allow you to choose either or, but quite frequently they have already highlighted the with survivorship piece, and that's what gets completed by my clients. Well, if you have 3 kids and you've only appointed your daughter Jane as your joint owner on that account, just merely for convenience purposes, the problem is going to be that she actually inherits that money at your death as the joint owner because she survived. She is now given a moral obligation, not a legal obligation, to share those assets with her siblings, if your estate plan consisted of leaving everything equally to the 3. This can create unnecessary drama, unnecessary legal expenses. And so this is probably the one tool that I often say, unless it's your spouse and you want to leave everything to your spouse, or unless it's your only child and you want to leave everything to that child, I don't typically recommend this. And I often wish that I could get a bunch of bankers in the room and say, stop doing this, because I do have clients, and I train them before they go to the bank, that will take the power of attorney, ask to put the power of attorney on file, and instead of recording the power of attorney, because it has to go up to legal for recording, it's a process, the bank teller throws this joint ownership piece of paper in front of my client's face instead and say, oh, this is so much easier, just do this. But the ramifications are huge. And so that's just kind of a word of caution. It's a tool, but it's one that I use very infrequently. Then we have trusts. So trusts serve a multitude of purposes, and it really depends on the type of trust that you're utilizing. So we have revocable trusts, meaning that they can be changed throughout your lifetime. And then we have irrevocable trusts, which are actually locked down. The irrevocable trusts normally serve a very specific purpose, such as trying to make a completed gift for estate tax purposes, or it might be to just really make sure that for public benefits purposes, those assets are no longer in your name so that we can start look back periods and all that other fun stuff. And so I always tell people the name of the trust to me doesn't matter as much. I could literally call it lipstick on a pig trust. And for me, that doesn't tell me anything. What really matters is what are the terms inside of the trust. So I do have clients that come in and it may be the Joe and Sally Smith trust or revocable trust. All it tells me is that I can change it based on the title, but it's really inside the trust agreement. I'm still going to look for a paragraph that says who can amend it, who can revoke it, does it have to be both people? And so I do have people come in and say, oh, well, what's the name of this trust or whatever the case may be. It's really the terms therein that matter, just so you guys all know. And then you have your will. So depending on the estate and the state in which you're in, your will may actually be the least important document. If I have a trust-based plan, I often tell people, I want to be able to tell your kids to just take the will to probate and record it and never see it. I don't want to have to look at the will to know where the assets go. You know, in a will-based plan, obviously the will is going to dictate out the terms of the way things are going to be disposed, but a pour-over will say move everything in the trust. And so there are various types of wills that can be put in place. A will is only effective at your death. So all these other tools are valid during your lifetime. The will is effective at your death. And so even if your kids called and said, well, you know, I'd really like my inheritance early, you know, there's ways that I could go about gifting and all that other fun stuff, but it would still create some sort of penalty for some of the benefits that we look at. But I often say, I don't really care what the will says up until the date of death. And the sole reason is that it's not effective until that point. Okay, so what are the defaults? So we just talked about the tools, but what if we don't actually use any of the tools to develop a plan? In the absence of a power of attorney or advance directive, or in the event that, like I said, those are just not sufficient enough to make or to carry out whatever it is that you need, Or sometimes too, I do have agents under powers of attorney that are just bad actors. We would have to go through what's called a guardianship and conservatorship proceeding. And I will tell you as a practitioner that anytime I got to go to court, it's much more expensive than if I was able to just do some documents and carry out whatever it is that needs to get done. Fundamentally, and I can only speak to really Virginia on this issue, but the fundamental thing that they're looking at is, does the person have the ability to make the decision? And if they do not have that capacity to, and they need the protection of the guardian conservator for that to happen, then they're incapacitated. The guardian will be able to make decisions related to the person themselves. So what type of medical care are they going to receive? Are they going to work? Where are they going to live? The conservator is the one that handles all the money. From experience, everybody fights over the money. They don't normally fight over the personal decisions themselves. So that is just kind of decision making during your lifetime. Every state's going to have different rules with regards to what that looks like. But big picture, you will have inventories that are going to need to be filed. So, and there's going to be accountings, because if the court is appointing somebody to oversee everything, they are going to want to document to make sure that the person that they've appointed is doing what they're supposed to do. So, you know, there's a lot of just court reporting involved. There are bonds that get posted to make sure that in the event you mismanage something or somebody mismanages your stuff, that the money can get put back in the estate and that insurance company runs after the guardian and conservator. I do see a question, so I am going to, Ms. Dickman, I am going to allow you to talk. You are muted though.
Hi, thank you very much. I have a question. I want to just step back a little bit about the tools that you mentioned. We have done our estate planning a long time ago. We had our first trust and power of attorney and wills, etc., put into place in 2005 when we were living in Northern Virginia, and then we moved to Charlottesville and we had them restated in 2016. We have revocable trusts, and it seems like, you know, all of our documents is pretty much in place. Do I understand that if we were to engage an elder attorney such as yourself, that anyone like yourself would look at these documents again and do some fine tuning on it, or would that, did I misunderstand that?
It depends on what it is that your goals and objectives are. So for instance, a revocable trust, in the event that I'm doing aid and attendance planning, a revocable trust isn't going to be sufficient to do that type of planning, because it's still in your name, you have control over it. And so for the VA purposes, they're going to essentially say, well, you still have control over it, so it's still an asset that's going to be accountable to the asset limit. So it really kind of depends on what it is you're looking at. Now, what I will tell you is there has been a major law change since 2016 called the Secure Act. And so when we talk about like retirement planning with regards to like IRAs, 401ks, some of the language inside even a basic revocable trust does need to get updated now as a result of some of that.
Okay, yeah, we did have our estate attorney take a look at it, and it seemed like the way he had phrased it all, you know, was still applicable today, because we just had that done. So I was just wondering if, you know, engaging an elder attorney would still be necessary, or if it's just a recommendation more than anything else.
It really boils down to, are you ready to start talking about long-term care planning? And then what does that look like? So in addition to being an elder law attorney, I do have my financial advisory licenses. I'm also licensed health license. I was an accountant before I was an attorney. And so whenever I look at something, it's not just like, hey, here's a trust and we're doing some probate avoidance, or, you know, we're just doing some death planning. I'm really looking at, are you at a place to where you're going to be able to retire or go into your assisted living facilities, or, you know, whatever it is that you're looking to do, and what other benefits may be available. So if you tell me, hey, my husband's a veteran and I want to start protecting the assets so that I can use the VA aid and attendance benefit whenever that happens, then that's a whole nother plan. But if you just say, no, as of right now, I'm just comfortable talking about death planning, then you're probably fine.
Yeah. Okay. Can I ask you another question? Do you recommend that one contacts an elder attorney in the place that you live in, or that doesn't matter?
It doesn't matter. So we have clients throughout the Commonwealth of Virginia, Pennsylvania, North Carolina. And so a good attorney is going to be able to utilize technology. They're going to be able to use like FedEx to get things done. You know, the most complicated piece is usually the notarization.
Sure. Sure.
And especially in Virginia, we don't have the remote notarization laws that some of the other states developed throughout all of this.
Okay, great. Thank you.
You're welcome. Okay. All right. So let's talk about, you didn't get a will, you didn't put a trust in place. What we're really looking at then is, what are the defaults under the law? And so this is where I think I get the most interesting questions throughout this all, or kind of the biggest eye openers. So blended families in particular can really disrupt what somebody might have intended. And so I do have families where husband and wife had children from outside their marriage, but maybe they've been married for 40 years. You know, they really built their life together. Well, most families think that 100% of everything's going to fall into the spouse. You know, if everything's jointly titled, yeah, it may end up being that way. But the default under the law actually says that the spouse would inherit 1/3 and the children have to divide then 2/3 of it. Well, not a whole lot of my families in that situation. That's not what they intended to happen. That's not what they wanted to happen. And so looking at kind of, well, what would happen if you didn't develop a plan can also become very critical. In the event you don't have a blended family, it does all pass down to spouse. Then if you don't have a spouse, they do look to children, grandchildren. If there's none of that, then what they're going to look at is parents, siblings, try and find your closest next of kin, and then usually out to the Commonwealth or the state. I'll tell you that even if you don't have family, I've never met a single family that wanted their inheritance to go back to the state. They usually wanted to at least go to a charity or one of their best friends or something like that. But if you don't do any planning, that's the way that it looks like, or the way it looks. The other big thing whenever I'm looking at these defaults is, regardless of what I put into play or whatever gets put in place, so like the guardianship, conservatorship, oftentimes whatever is done, the court is very hesitant to allow for the change of beneficiaries. So I usually have to go to court and say, hey, by the way, this bad actor under the power of attorney put herself on all of these accounts so that she can inherit them at this person's death. Can we please get the express authority to either remove that beneficiary designation or to otherwise name people? And then if I have a trust or something, to be able to say, okay, can I update this beneficiary designation to make sure it's flowing into the trust? And so that's also going to be an issue in the event that I need to ask for gifting powers for long-term care planning. And so every court is very, very different in the way that they handle these things. You know, I do have an office in Virginia Beach, and they're probably the most strict and, you know, really want to know what the plan is before they're going to give any of that power. All right, so I mentioned this a little bit ago. Effective January 1, 2020, we have a major law hit. So while we're all celebrating Christmas, Congress is busy passing this law. This is going to impact anybody that has an IRA, 401k, 403b, 457 plan. So basically all your retirement accounts. And essentially what happened was they were looking for a way to generate more income, or, you know, generate more tax income. And so what they did is they actually increased the required beginning date. So when you have to start pulling what's called your required minimum distribution up to age 72. So it used to be 70 and a half. And then what they did is they basically said that at the death of the IRA or 401k account holder, everything had to be distributed within 10 years of death. A lot of the organizations that I'm a part of course, were like, well, this isn't fair to certain classes of individuals. And so what they did is they when they passed the law, they did include what are called eligible designated beneficiaries. And so these are exceptions to that 10-year rule. So a surviving spouse still has all of the options that they had prior to the passage of the Secure Act. So they can either roll it over into their own IRA so that they can basically delay taking anything from it, and then using their own required minimum distribution. They can still get an inherited IRA whereby they stretch it out of their lifetime, or they can just take it lump sum. So surviving spouses do have the most flexibility with regards to any of this stuff. The interesting thing, however, is that if it's a surviving spouse and you are leaving your spouse's inheritance in trust, and I do this for estate tax planning sometimes, the language or the law specifically says that it has to be what's called a conduit trust, meaning that as soon as the distribution comes in, it's got to push right back out. And so that is one thing that we often have to look at whenever it comes to surviving spouses and the overall plan. Is it what's called an accumulation, meaning that we can keep those distributions inside the trust, or must we push them out? So for surviving spouse, in order to get that stretch, it does have to be in a conduit trust. We also have a child under the age of 18. And what this rule is, once again, you have this conduit where I got to push it out, but basically you get 10 years plus whatever amount of time it takes for that child to turn 18. The problem is that with that conduit trust, not too many people want to push out, several thousands of dollars to a minor child that may or may not need it. And so a lot of my clients have basically indicated, no, I'm going to keep it in accumulation. There's no sense, I understand that I may lose a few years, but at the same time, I don't necessarily want to have to push this out just for the sake of, a couple years extra deferment in that pullout. Disabled or chronically ill persons actually come in together, and essentially what they did is they did say that you can pull out over an individual's complete lifetime if they have a disability or a chronic illness. And then what they also said is this is the only time that we see accumulation trust language. And the reason why is that I know Special Needs Alliance, I was on the list, so I was watching this as it was going through. And what they were really looking at is if I have a special needs trust, that is an exempt resource for certain benefits such as SSI or Medicaid for my kids that were disabled since birth or whatever. If I had to just push it through, that would disrupt all the benefits. That would disrupt the purpose of what a special needs trust is. So Congress did hear the disability organizations and say, okay, we will allow you to have the accumulation trust for those exceptions. So that was a nice little win that we did get there. And then the other exception is for individuals not more than 10 years younger than the employee, they can also do their lifetime stretch that we saw pre-secure. If you do have retirement accounts and there were documents that you had done prior to January 1st of 2020, then it is important that you meet with your attorney just to make sure that you do have secure compliant language built in there. All right, so what are the potential tax changes? So this is something that is a very hot subject right now. And interestingly enough, I wrote something about the loss of step up in basis, I think 2 weeks ago for a newsletter. And then Lisa McDowell, who is excited that her NAILA presidency will be defined by a new tax bill because she loves tax. She just wrote another article kind of what we're looking at. So there's multiple bills right now. We don't really know what's going to happen. But some of the changes that we do see is that there's going to be an increase in tax rates. It's all over the board as to what brackets are going to be impacted. Originally it was for those individuals making $400,000 or more. However, some of the recent legislation does bring that down to include lower thresholds, increased tax rates. We're also looking at step up in basis. So this is huge whenever it comes to long-term care planning. And so what this means, and I did an entire article on this, is if you bought a house, let's say for $10,000, or you inherited a house for $10,000, that's what's called your tax basis. It includes then like any modifications you may have made to it, but essentially I just want to basically say you bought it, you didn't put any work into it, let's just keep it there, nice and clean and simple. Well, at your death, it may be worth $100,000. If I lose the step, currently under law, what happens is the value, basically the value of your asset jumps up, or the basis for your heirs is going to jump up to what that value was at the time of your death. So at $100,000. So when they sell it, you're not subjected to capital gains. If we lose that step up in basis, when the kids sell your house, they're going to actually have to pay capital gains on the difference between the $100,000 that they sell the house for and the $10,000 that you actually had invested in for that purchase. So it's subject to a $90,000 capital gain. And that's it. It's not full. It's taxed at certain rates, and there's different thresholds. There's like 0%, 15%, 20%. They are talking about actually in not only eliminating that step up so that they can tax more capital gains, but they're also talking about actually increasing those capital gain tax rates. What I just said is currently we're looking at a max 20% tax rate. There's been something thrown out there that it may even look like 40 to 45%. And so that is something that we're looking at. Now, when we are developing plans, sometimes I have people who say, well, can't we just give the house to my kids? Like, I want to just give it to my kids so it's out of my name and I start whatever look back period I need. The problem with that is your kids will lose their step up in basis. And so that is often, especially in the current regulatory scheme, that's super important, because if it's not their primary residence, they're going to be exposed to massive capital gains that we otherwise could avoid if we do proper planning. There are trusts that will still allow me to start a look back period. And basically what I say is it is a completed gift for public benefits purposes, but for estate tax purposes, it's included in your estate because of certain powers that we keep in there. And so as a result, it will actually, you'll get to continue that step up in basis, and we don't have to worry about that little tax loophole. And then the other thing that we're looking at is a decreased estate tax exemption. And so very few of my clients have to worry about this, but we currently have a $10 million exemption that's adjusted for inflation. We know that December 1st, I want to say it's 2026, it may be 2025. I've talked about this multiple times today and I just can't remember which year it is, but we know that's going to drop down to 5 million adjusted for inflation. There is talk that they want to drop it down to 3.5 million. And so for any of you guys who have an estate tax issue, that is something to kind of stay on the lookout for. They're also talking about increasing the estate tax rate as well, which is already pretty hefty. All right, so now we're going to get into the nitty gritty of not just like regular estate planning, but really what's long-term care planning. And so when we're looking at, okay, yeah, we've gotten all this document so that we can do something, we're really looking at, you know, what is it that you need done so that you have a continuum of care that is going to build in any public, private, and community-based types of care that you may need. So long-term care can be delivered inside the home. It can be delivered at an adult daycare center, just so that somebody can get out during the day. It can be in what's called a continuum of life care community. So we call them CCRCs, continuing care retirement communities, or assisted living communities, or nursing homes. Really, I didn't put that in there. On average, 50 to 80% of cognitively impaired individuals, or when you look at the makeup of an assisted living community, on average, it's between 50 to 80% of cognitively impaired individuals, and they're going to need assistance with about 2.8 out of 6 activities of daily living. So whenever I'm looking at what is an activity of daily living, what I'm looking at is, can you physically feed yourself, bathe yourself, dress yourself, go to the bathroom, walk, and transfer. And so that is when I start talking about what benefits are available. That's really what we're looking at. You know, when we get into like a nursing home level of care side, those activities of daily living have started to increase. Essentially, you're pretty immobile and need help with pretty much everything that's going on in your life. The downside, though, is if you've ever walked into an assisted living facility versus a nursing home, it's really the quality of life. You know, in the nursing homes, they don't develop engaging activities. It's very hospital-like setting because it is a facility. Whenever I look at some of my public benefits, it kind of just mirrors directly in with the hospitals. Your assisted living facilities are much more vibrant. They are going to want to make sure that their residents are engaging in social activities. They are going to have a different quality of even meals and kind of a little bit more access even throughout the day, so that if somebody, you know, just wants a snack or a sandwich, that's going to be a little bit more readily available. You know, there's going to be a lot more flexibility about kind of coming in and out of the community. The visitation's a little bit easier as well, especially whenever we hit the height of COVID. And so it's very, very different lifestyle. When we start getting into benefits though, that's whenever you start to see, okay, well, we might get stuck with one thing or another if we don't plan now. Services in these facilities are, in the types of different care environments can be skilled, intermediate, or just plain custodial. And then the largest part of long-term care is actually the custodial care. So usually that's the most expensive piece, is just kind of that roof over your head kind of piece. And then it's just intermittent based on kind of what you need. And then if you do need assistance with your activities of daily living, that usually then does increase the cost of care for you. All right, so the first thing is, the vast majority of my clients, when they walk in, they're Medicare eligible. And I always get to pick on my father-in-law whenever I talk about this and any veterans benefits, because he does fall into this. He became disabled younger. And so it's nothing for me to be able to talk his stuff because I don't have attorney-client confidentiality. So big picture, Medicare is not designed to address custodial long-term care needs, and they don't do so. And so one of the basic misconceptions is that, well, whenever I go to a nursing home, they're just gonna, Medicare is just gonna pay, or if I need to go to assisted living, they're gonna pay. The answer is not going to happen, because quite frankly, Medicare is what's called an acute care policy. And so it's designed for short-term medical treatment, such as at a hospital or a doctor. I often use the example of, you fall and you break your hip, they're going to pay for your surgery, they're going to pay for your rehab. But at some point, if you never walk again, just because maybe, whatever it is, you're just too weak to do it, they're going to stop paying. So just being inside the nursing home because you can't walk, or inside an assisted living facility because you can't walk, Medicare is going to say, sorry about your luck, you should have planned for this. So, I see this a lot too with my TRICARE, my retired veterans, because they're so used to TRICARE really covering a vast majority of what they need, but in the long-term care context, they're still an acute care policy. And so usually whenever I'm looking at, what pays for long-term care, it's really going to be long-term care insurance is the only quote unquote insurance that's going to be available. Medicare will cover skilled care under limited circumstances. When Medicare does pay for that nursing home level of care, because that's all they pay for, it has to be provided in a skilled nursing facility, or they, can be at home. The care must be provided within 30 days of a prior hospital stay of at least 3 consecutive days. And so this is one of the big issues that I often see whenever I start talking discharge planning, because the hospital, they may have been on what's called observation status inside the hospital. And so when there's a discharge, they haven't met that inpatient hospitalization because they were on observation status. If they're not actually admitted inpatient to the hospital, you don't start that 3-day period. And as a result, Medicare will not pay for any long-term, or, the rehabilitative costs associated with that, whatever the hospitalization was. The other big thing is too, is that the care must be restorative in nature. And so it has to be made to get the patient better. It's not designed to just kind of maintain that. All right, so this is kind of the biggest benefit that we see in regards to assisted living. Some states have very robust assisted living programs, and just kind of depending where you're at. What I would tell you is in Virginia, we have one assisted living program, and I call it the laughing stock of all programs. And that's because the criteria to be able to get the program is so onerous in itself that not very many of my clients, even with some of the nifty tools that we do have in our tool bag for long-term care planning in particular, the income piece of it is essentially in retirement, you can't have more than $1,200 a month in income, about. And so that's really hard for a lot of my retirees that are, because they're making more than that in income, and I can't do anything about that. But then even if you do qualify, you can't find anybody to really take it. So most of my assisted living stuff is going to be private pay. And that's why the type of care you get is a lot better inside these facilities, and you become part of a community instead. But one of the benefits I can look at is the veterans benefit. So most people are very familiar with the compensation side. So that's your service-connected disability benefits. So basically, in order to be eligible for that, you had to have had some sort of disability onset as a result of your service that you've had in the military. The VA itself will provide actual nursing home care to service-connected individuals if the care is directly related to that disability, or if they are rated disabled above 70%. And so my father-in-law at one point in time was only about 50% disabled. And so he really didn't get a whole lot of services available to him. Now that he's 100% service-connected disabled, he has a lot more available to him. Now, one of the big things is you can't double dip in the VA system. There is another benefit that's called the pension benefit. That is for those that do not have a service-connected disability. In order to be eligible, the veteran must have served 90 days of active duty, 1 day of which was during a period of war as defined by the VA. So if you go to the Department of Veterans Affairs website, they do have very defined periods. The most confusing period of all of this is usually in the Vietnam era, because there's 2 time periods. There's one for people who actually serve boots on ground. They've started further defining that, like even if you're on a ship outside of Vietnam, that would still count, because that was kind of a little gray area up until recent. And then there's also a period of time where it didn't matter where you were in the world as long as you were serving during that period of time. And your discharge had to be honorable. In order for this benefit to kick in, essentially the veteran has to require care or assistance on a regular basis. This is a needs-based program. So your service-connected benefit, hey, I got injured while I was active duty, and as a result now I'm entitled to this benefit. That is not the way the pension works. Instead, what they're looking at is, do you have assets in excess of $138,773? They're looking at all of your bank accounts, cash value and life insurance, annuities, life insurance, CDs, money market accounts. Basically, if you can turn it into cash, they want you to do it. Now, that said, they do exempt out your primary residence. So a lot of the planning that we do in terms of veterans benefits is really putting a shell over the house to make sure that that's protected long-term, regardless of kind of what happens. There's also an income test, and basically what they look at is what's the max benefit. So let's say the max benefit is $2,000. I'm just arbitrarily picking a number because that is not any of the max benefits. But say it's $2,000, but your income is actually $3,000. On the surface, they would say, sorry, you're not eligible because you already make more than that. However, if you're paying $6,000 a month for an assisted living facility, they will allow you to deduct that out as a medical expense. And because you have a negative income, you would be entitled to the full $2,000 benefit. So that's what you can see there is there's a service requirement, there's a medical needs test, there's an income test, and an asset test. There is a 36-month look back period. So people are often very familiar with a 5-year look back period. The VA has imposed a 36 or 3-year look back period subject to a 5-year penalty period. And so the timing of applications when I'm doing planning becomes super important, because as opposed to just going through a 3-month penalty, if I don't time the application right, I could accidentally subject my client to a 5-year penalty or a 5-year wait. And so that's why I often tell people, do not submit a single thing to the VA without talking to somebody who's really knowledgeable in the timing of this stuff, because even just putting an inquiry in could present a problem. All right, Ron, I do see that you have a question. It's going to allow me to do this. There we go. Ron, what's your question?
No, I didn't have one.
Oh, okay. For whatever reason, the hand came back up again. No problem.
Well, maybe my hand is still up. I don't know how to get it down.
It's gone now. Okay. All right. So these are the amounts that we're looking at for 2021. So really what we're looking at is, who's the person applying? Is it a veteran? If it's the veteran themselves, do they have dependents? And if so, then the value changes. The other thing we're looking at then is there is a surviving spouse benefit. They do not have a spouse benefit, but a surviving spouse benefit. And so if you're a veteran and your spouse needs to get care, The issue then becomes there's what's called a low income pension benefit, but usually it allows the veteran to live off of like $800 a month. That can be really, really cumbersome for my clients. So it's really hard to make that work. But so the surviving spouse can be entitled to something provided certain criteria are met. And then there is a veteran married to another veteran benefit as well. Okay. So aside from the veterans aid and attendance and Medicare sometimes being able to help chip in, the other thing that we look at is just general old income and savings, that financial planning component to all of this. So if I am paying for a facility of $8,000 a month, and I really just picked an arbitrary amount, and because different states, their averages are just completely different. So whenever you're giving a presentation affecting multiple states, it can be problematic. So that would be $96,000 a month. In-home care, even though that's kind of where everybody wants to be, you know, going into some of the positives of getting out of the house, you know, we are social creatures. Erica indicated that, you know, in the beginning of the presentation. But as we age, the ability to get out and we kind of become a little bit more confined to the house, that's detrimental to somebody whenever they have dementia in particular. They need that stimulation to keep them going. And it's amazing that over the years of practice, I've seen somebody who didn't function very well. And the second they're placed into a more vibrant and inclusive community setting where they're being stimulated a little bit more, they actually start developing a little bit better. Now that said, I've never seen somebody go from complete dementia to, hey, I'm perfectly fine and I can leave again. But, you know, it does improve their skill sets and it allows them to start engaging a little bit more. So in-home care in our area is about $25 an hour. So if I'm looking at $25 an hour, 24/7, that's $219,000 a year. That is the most expensive type of care you can get because it's one-on-one. So let's say that those are your costs of care. You have income of $24,000 and savings of $500,000. So you have your annual withdrawals. And basically when you back into it, that same $500,000 in income, if you go into a facility, even at $8,000 a month, that's going to last you for almost 7 years. On the flip side, if you're staying inside your home, not only do we have those other incidental benefits of going to the facility, but your money depletes much quicker. And so really good planning and understanding kind of, can we really afford to stay in our home? And is that the best option? May not be beneficial, because if you get in that situation where you run out of money in 2.6 years and you're full ADL care, you're probably going to end up in one of the nursing homes that are not going to provide that vibrant stimulation that you could have otherwise had an assisted living facility that would allow you to prolong and stretch out those assets and engage in a community-like setting a little bit longer. Long-term care insurance. So usually when my clients walk through the door, it's too late to start looking at some of this stuff, especially like if you're coming in saying like, hey, I need to use long-term care insurance. The insurance companies are not stupid. If you need to use it, then you're ineligible for it, essentially. In order to determine whether or not long-term care insurance is appropriate for you, we're really looking at, do you need it? Can you afford it? What are the benefits that are best for your specific needs? So for instance, are we looking at a lifetime policy? We're looking at a 10-year policy. We're looking at a 5-year policy. Or do we want to turn on a life insurance benefit? So that way, if you never use your long-term care, that we can make sure that there's something payable to your estate or your heirs, and it's not all that money's lost. The other thing that we often see is that families have a lot of money in qualified funds, so your 401ks, IRAs, and there are certain policies that we can look at that will allow you to use those assets to lump sum a purchase for long-term care insurance. And so you're not creating a distribution by actually funding your long-term care insurance. I have seen people actually pulling out from their retirement accounts just to pay their long-term care insurance premiums. They do have some rollover benefits. So there's a lot of different hybrid policies out there that are pretty good for clients now. And then which of the plethora of plans actually makes sense to your very specific individual needs. All right, so then we get into Medicaid. Once we've gotten into Medicaid, you have to be pretty bad off at that juncture. So essentially, in order for Medicaid to turn on for long-term care services, we're looking at, you need assistance with at least 3 out of 6 of your activities of daily living. So that's that feeding, bathing, dressing, walking, going to the bathroom, and transferring. So this, under Medicaid policy, is what's called skilled nursing care level. So if you have basic dementia, you can't come into my office asking me for Medicaid just because you need protection from burning the house down. Medicaid doesn't care for that. We don't have an Alzheimer's waiver. We don't really have that assisted living waiver that I told you about. The asset and eligibility rules for Medicaid are extremely complicated. I think the number one complaint I get from my clients is, well, I tried to call the eligibility worker and she basically told me she couldn't tell me what to do. Their job is not to help guide you through the process so that you're eligible for benefits. Their job is to review the application to determine whether or not you're eligible. And quite frankly, half of them don't understand why we use certain techniques that we do in order to protect assets. When I'm looking at a Medicaid plan, my entire goal is to get eligibility as soon as possible while also protecting as much money as what I possibly can. The rules are going to vary substantially from state to state, and they're constantly changing. Every time I turn around, there's a new policy from either, even on the listservs that I'm on, in Pennsylvania, they were just talking about something the other day. So these rules are constantly changing. Sometimes they're now having independent contractors that are actually overseeing some of this stuff, which only further complicates the issue. Most of the time, we're looking at $2,000 asset limit with subject to that 5-year look back period that most people talk about. Now, a 5-year look back period does not mean that you gifted $2,000, so you're forever banned for 5 years. What it actually is on the Medicaid application, it says, have you made any substantial transfers in the last 5 years, or have you made significant uncompensated transfers in the last 60 months is actually what it says. And so if the answer is yes, then they're going to impose a penalty period. Essentially what they're going to say, and absent some exception, because there are exceptions to transfer penalties, such as for a spouse, a disabled child, caretaker child. And so essentially what they're going to say is for every, and these are Virginia numbers, for every $6,422 you've given away, we're not going to pay for 1 month. And so that's really what that penalty and what that look back period is. There's a lot of misconceptions to what that actually means. You do need skilled nursing care unless, and like I said, I define that based on Medicaid, that 306 ADLs, unless you're under a very specific waiver. So I do have, we do have what are called the My Life, My Community waiver programs here. And those are for intellectual and developmental disabilities for kids. And so those criteria are a lot different. That's not normally what I'm talking about in this type of presentation. Don't ever rely on advice from friends and family, because what worked for them may not work for you. For instance, their mom and dad may not have had a 401k IRA, but your parents do. Well, if I liquidate that, I've now generated income taxation. When I'm looking at this, I'm looking at, how do I get the benefits? How do I protect benefits? What are the tax consequences involved? And so there's a lot of different moving parts that it's just not a one size fits all solution. Medicaid's a term that's given to a multitude of programs, all with different eligibility. So there's basic health insurance pieces to all of this, such as under the CHIPS program. We do have Medicaid expansion now here in Virginia. We have waiver programs. We have classic, what's called ABD Medicaid, to just pay, like if you're age blind or disabled, to be able to just have generic health insurance. And so it's really just kind of understanding what works for you. Now, that said, this is probably the #1 program that people want to look at. Why? Because it takes the reins out of your control. But what it doesn't do is it doesn't give my clients that quality of life sometimes that we're looking for. And so that's why this may not long-term be the best solution for you or your family members, just as a result of, because either the benefits are not available or it doesn't provide the quality of care that you really want for your loved one. And then finally, we just look at the words for the whys. Don't try any of this at home. I just saw today a LegalZoom will, and unfortunately, the family's going to have to pay a lot more money than what would have even cost to get a professionally drafted will as a result. And I use LegalZoom as just like a generic online or like self-created online will. But really seek the advice of experienced elder law attorneys if you're looking at long-term care planning. This is what we do. So as we discussed earlier, we know the facilities, we know the players that are involved. There's, like I said, there's tax law, there's, the financial components to this we're looking at. What should we tap into retirement assets? Should we use insurance policies? Should we make sure that we at least have basic estate planning involved? How does this all interplay together, especially if you have a blended family? Because your wife may want one thing, you want another in terms of estate planning. And oh, by the way, one of you guys need care. Where are we pulling the money from? And what's the overall impact on your plan? So it's much more complicated than just saying like, hey, this is what we're going to do. There's many options. And so we always say there isn't one single option. I get a family in here, let's say it's husband and wife, there's $100,000 worth of assets. There's multiple different tools that I have to develop whatever that plan is that they're looking for. And there's no easy cure. I often tell people that, I'm not a magic fairy. I don't have a wand that's going to make everything go away. But our goal really is to minimize the detrimental impact of the aging process and the disability or disability diagnosis to the overall family. All right, and that's it for the presentation. So if anybody has questions, please feel free to ask. Nobody typed any questions into the Q&A while I was speaking.
Shannon, I just wanted to thank you. This is all really complicated, frankly, kind of scary stuff, and you do such a nice job of making it feel a little less frightening. So thank you.
Oh, you're more than welcome. I do. I always tell people I'm not like the pearl uptight attorney, and it's just because I do have to deal with such complicated stuff that if I start throwing out fancy words and everything else, that doesn't really benefit my clients. I really want them to understand what it is I'm talking about and understand the plan that's getting put in place. And my main name's layman, so I try and speak in layman's terms. Ha ha ha. So look,
that's great.
All right, so I don't see any hands raised, and nothing in the Q&A yet. Oh, I do have some hands raised. All right, so I am going to, Ms. Dickman, I just unmuted you, or I just asked you to unmute.
Thank you.
You're welcome.
Thank you. Should all elder attorneys be familiar with local facilities and be able to place patients or their clients?
Yeah, we work with them all the time. So the only thing that sometimes happens that throws us off is that every once in a while a facility will get bought out by a new company. And so I'm actually going to pick on Commonwealth. So they bought Cedar Manor out here in Hampton Roads. And I had no clue that it came under the Commonwealth umbrella. So somebody said something. They're like, "No, we met with Commonwealth over Cedar Manor." I'm like, "That's not what are you talking about? It's not a Commonwealth facility." And so sometimes that'll happen. It just goes under like new management or gets a new name. But for the most part, once they can track down the location, they're going to know that facility. So a good elder law attorney is going to know the nursing homes, the CCRCs, the assisted living, the memory care units, everything in that area.
Okay.
So don't ask me about Richmond or Charlottesville. Those are not my immediate. But what I will tell you is I do know the Commonwealth facilities around the Commonwealth.
Right. I understand. In the beginning, you mentioned something about an organization of elder law attorneys, and I missed what that was. Would you mind repeating?
So the first one is NELF, NELF, and that's the National Elder Law Foundation.
Okay.
So those are going to be those of us that actually have our certifications. And like I said, there's only about 500 of us in the country.
Okay.
The other one is going to be NALA, which is the National Academy of Elder Law Attorneys.
Okay.
And then sometimes you can find somebody on the Special Needs Alliance as well. But they're going to be much more focused and tailored to disability onsets prior to age 65.
Okay, thank you. Thank you very much. And will we be getting the recording sent? Is that something that you do?
Yes, so everything is being recorded. My IT guy will clean it up just a little bit because of the very beginning. I logged in about a half an hour early, so there's like a half an hour of just a blank screen. So yes, we'll get that edited and out.
Great.
I don't know who maintained the attendance list. Erica, do you have that?
I'm going to reach out to Skylar because we only have a few, but I feel like Skylar probably has the full list.
Okay. Either way, if you don't hear from us and get this circulated, I would say probably within the next 2 weeks. Don't hesitate to reach out to either Erica with Commonwealth Senior Living or my office to basically ask for a copy of it.
Great. Thank you very much. This was
You're
very helpful. Great presentation. Thank you.
Thanks. All right, and then Ron.
Missed your name on the first chart.
Oh, sorry, it's Shannon Lehman Pecoraro.
I want to say it again.
It's Shannon, and the last name is Lehman Pecoraro. That's LAYMON-PECORARO. We did a bunch of different live presentations around the area, and so usually on it has like my photo and my designations and all other kind of stuff on the front slide. But since multiple of us were using this presentation, the names got removed. So sorry about that.
It's okay. I just missed it. That's all.
All right. Anybody else? All right. I see something in chat. You're more than welcome. All right. It doesn't look like there's anything else. So I'm going to go ahead and Erica, do you want to say anything in closing?
No, just to repeat what you had said, if anyone is interested in a cost comparison tool or any follow-up collateral, we're happy to help. There's a plethora of guides available that we can send to you. So if you'll shoot an email over to marketing@commonwealth.sl, we can get you this recording and anything else you're interested in. Thank you all for joining.